today we have our own Paul Cavise, who you've probably seen in the audience from time to time. Today he's up here with me. Paul he graduated from he's a graduate of the United States Military Academy at West Point. There he had a Bachelor of Science with dual concentration in both engineering and the French language. He attained the rank of colonel in the U.S. Army before retiring, and he also holds an MBA from Fairleigh Dickinson, where he studied management and operations research, which is what I majored in. We'll have to talk about that sometime. And he also has
all my papers that I wrote.
He also has a Juris Doctor from Rutgers University, which means he's a lawyer. And there he studied both corporate and estate law. Back in 1980, he founded the Computer Law Corporation, and over time, he later became a vice president at Goldman Sachs. So he's been all over the place doing all sorts of interesting things.
Very, very old.
And so he, after 20 years in the military and 30 years practicing law, he now teaches business law and constitutional law to college freshmen and sophomores. And so it's in that capacity as a professor that he comes to talk to us about the Bill of Rights. So please give a warm welcome to our own Paul Cavise.
I disappointed my mother because, do I turn the mic on?
Yeah.
Is that what you want me to do? You give me that dirty look. I'm so loud that I don't want to have to overcome you with... Okay, is it on?
Yeah.
Well, I disappointed my mother because she said, get ahead, get ahead, get ahead. So I went and got all these degrees, and then she said, no, I'm terribly disappointed, you haven't made me money. So I got all these degrees, but it got me nothing, not even my mother's respect. Thank you, Humanists, for having me today to talk to you. But most importantly, thank you, Humanists, for providing a sanctuary for me for all these years that I've been a member. And I appreciate that very much. I'm going to take you, it's a summer day, thank you for taking time out of the summer day. I talk fast. And, but I'm going to begin your summer day with a really fast roller coaster ride through the Bill of Rights. I have to go fast. I have to save comment till the end. Eric's been very kind to give me more time. And I'll try to get through all 10 plus the 14. I don't know that we're going to be able to do that, and I'll have to just play it by ear. Okay, recent events have made me redo this lecture within just the last few months. Our Bill of Rights is rich, as you know, with constitutional challenges. We all must find the same solace in defending the Constitution that, for example, religious people find solace in the Bible. My tattoo reads Supremacy Clause. The audience the audience here that I'm speaking to today will be a little difficult because you're not, after all, college students who define their world around Facebook. But I can boldly assert anything in class, and with very little objection. I expect our time together to be different. I expect you all to have an informed opinion, many of which I'm sure I'm not prepared for. I'm going to try to leave time at the end, as I said, and afford you the opportunity to comment on your understanding of the bill amendments, which I look forward to, because I would like to have that. You are not being graded, so you can find consolation in that. The Constitution, just by way of background, the Constitution starts "We the people." When you go out and you leave this place today, go to your friends or your family and say, what's the first word in the Constitution? Now you know what it is. It's "we." Who knows the first word in the Declaration of Independence? Anybody? When? Whoever said that? When? That's a good trivia question. People don't get it right, ever. The history is constitutional, 1787, September 17th, consisted of a preamble and Articles 1 through 7. The Constitution was ratified over initial objection of James Madison, who believed we needed a Bill of Rights, which was not in the Constitution. Though a Federalist, he believed the nation's powers will be derived from the superior power of the people. He proposed 12 amendments. 1 week later, after the signing of the Constitution, only 10 were ratified in 1791 by then the states of the United States and became known as the Bill of Rights. The 2 amendments not ratified at that time had to do with congressional pay raises and were not ratified until 1992. Articles 1 through 3, I have to cover this. I know it's not the Bill of Rights, but background. Constitution's important as background. We all talk about constitutional crisis today, and we don't know where it is derived from, the Constitution or the amendments. It's both. Articles 1 through 3 I'll cover briefly. As you all know, establishes 3 branches of government, and that is a checks and balances, according to our founders. Legislature makes laws, executive vetoes laws, and judicial reviews laws. That's the way we're set up. Article 1 establishes the Senate and House of Representatives, 1/3 elected every 2 years, 25 years old, citizen for 7 years, no title of nobility, no profiting from office, power to, excuse my emphasis, because this is a non-political speech. I know, it's hard. Power to tax, coin money, make war, impeachment, and to make laws to give effect to their powers. Section 8, for example, in Article 1 talks about a commerce clause where the federal government has exclusively the ability to regulate trade between foreign nations, several states, and between Indian tribes. We had the Pittsburgh coal miners, the famous landmark case where the coal miners struck, and it was having effect. Even though it was in Pennsylvania, it was in Pittsburgh, it was not interstate. It had an effect on interstate commerce, interstate, not intrastate, interstate commerce. So therefore, we sent the federal troops in to stop that Union strike. Article 2. Article 2 establishes the executive branch, that's the president. Natural-born citizen, 39 years old, resident for 14 years, makes treaties, appoints judges with advice of the legislature, and is commander-in-chief and can veto laws. Article 3 establishes the judiciary, extends to all cases arising under the Constitution, except impeachment, including diversity of citizenship, admiralty, interstate commerce, arguments between states. Judicial review was established in Marbury versus Madison in 1802, when Chief Justice Marshall said a law repugnant to the Constitution is void, and therefore immediately established judicial review. The Supremacy Clause, as I spoke about before, says the Constitution is supreme. States can be only more restrictive, not less restrictive. That's a little contradiction in, like, for instance, states now are allowing marijuana, and the federal government has a law against marijuana. So, I mean, that's a contradiction. That shouldn't be, but they're just not enforcing it. So if you're confused. Federal preemption, such as exclusive jurisdiction in foreign relations, is part of the Supremacy Clause. Okay, amendments. We're going to discuss 1 through 10 and 14. Without 14, there would be no 1 through 10 in the states. The states could ignore 1 through 10, but for 14, they no longer could in 1868. Think of the amendments as an embryo. This is an important concept. Think of the amendments as an embryo. They never existed before, anywhere else in the world. Today, we see a developing spine. Let's call that the First Amendment. We can see eye sockets, but no eyes yet. Let's call that the Second Amendment. We can hear a heartbeat. Let's call that the Third Amendment. And so we have arms and legs, but we don't have fingers and toes yet. That's the Fourth and Fifth Amendment, and so on. The Bill of Rights needs to grow. What controls that growth? Statutes, common law, and the courts. The Bill of Rights is not a law. A lot of people misunderstand that. It's just simply a concept. Plessy v. Ferguson, for instance, in front of the Board of Education. Plessy v. Ferguson in 1896 said that blacks are They're equal, but they're separate. Brown versus Board of Education 1954 said no, blacks are not separate, and they are equal and not separate. And this is how it evolves. This is the growth of our amendments. Number one, religious and speech. Number one, freedom of religion, speech, and the press. Rights of assembly and petition. Congress shall make no law respecting an establishment of religion or abridging free speech in the press. Religion, I'll talk about first briefly. The history of freedom of religion originally intended to apply only to the federal government. Many states had their own official state religions. Jefferson had to resolve a power dispute one time between the Baptists and the Congregationalists in Connecticut, which led to his quote-unquote build a wall speech. Until 1830, even Massachusetts was officially a Congregationalist state. Okay, as to establishment and free exercise, I'll talk about establishment first and then free exercise. Doing all right? Yes, a lot. Okay, I don't know if I'm going to do it. Government must neither enhance, like declare the U.S. a Christian nation, nor inhibit, like tax churches. They will do neither. The court used the build a wall, Jefferson metaphor, in 1947 to define the limits of the Establishment Clause. The New Jersey decision that came later blurred that wall when they said that school boards have to pay for transportation to go to parochial schools. So it's like going back and forth. Lemon blurred the wall again and said total separation is not possible. Does the government lack a secular purpose? Does the government have excessive entanglement? These are the questions we must ask, not a wall. Grumman came back though and strengthened the wall and the theory of Everson, deciding government should not prefer one religion to another, or a religion to an irreligion, they called it. School pledges. Students can remain mute. A religious monument on federal land is still unsettled, including "In God We Trust," quote unquote, on our currency. William O. Douglas, who I really respect a lot, and this is the one thing I hate about him, said, "It encourages a general belief, no favoritism." I mean, I don't hate him, but I disagree with him. On "In God We Trust." Okay, that's just some examples. Free exercise. Free exercise is also in the First Amendment, and it says no law can prohibit how people express their religion. Reynolds in 1878 said the court cannot interfere with religion, opinion, or belief, with the exception, the court mentioned, of human sacrifice. They made an exception for that. Sherbert in 1963, the government needs a compelling interest to regulate, and that was in regards to working on Saturday. You know, the government says you have to work on Saturday, and of course, a certain person didn't want to work on Saturday. So, and the court found for that person, the government didn't have a compelling interest to stop him from not working on Saturday. It was okay. The Religious Freedom Restoration Act in 1993 codified the compelling interest argument, but was struck down in Flores in 1997 at the state and local levels. So the Religious Freedom Restoration Act still applies at the federal level, but it doesn't apply at the state level any longer. You all know the story of the street corner with the preacher. Somebody stands on a street corner, gets the same 10 people to come every Sunday, stand around him while he talks. He is a religion by constitutional law. Stephen told us about the flying spaghetti monster and Pastafarianism. You've all been here for that. And the pasta strainer is a symbol of one's religion. It is a matter of free exercise for which the government has no compelling interest to prevent. That's the law on religion. Speech. History of speech, 1776. All state legislatures declared the freedom of the press can never be restrained by a despotic government, quote unquote. Strong resistance to the Constitution came from Virginia, New York, Massachusetts, everywhere, without formal protection of speech. I'm going to talk about 4 types of speech. And then we're going to get to a crossover speech and religion, which is what's happening today. Political speech. Government strives to limit political speech. Naturally, the government doesn't want you saying anything. They want you quiet in your home watching TV. Reality shows, hopefully, because he owns most of those. Government strives to limit political speech, but greatly expanded it, ironically, in Citizens United versus the Federal Election Commission, where it said corporations are associations of citizens, and therefore they should have speech too. And then every PAC was formed thereafter that supports every political cause that there is. It was just, it's Supreme Court, it's just a contradiction. There's two types of political privileges with regard to speech, political speech. The first privilege is absolute. There's an absolute and there's a conditional. Absolute privilege is truth and opinion. I always preface everything I say in my classrooms to protect myself. It's my opinion. Okay, I'm allowed to do that. They can't really bust me for that. But, and you should do the same thing. Everything's your opinion, and you're allowed to have your opinion. There's a university sexual harassment policy that the court found was overbroad because they did a dress code. And they busted a student and expelled him from school because he wrote a blog or a podcast or something criticizing the dress code for women, the women's dress code. They said he was violating sexual harassment policy and threw him out. Of course, he was readmitted after he went to court because he's allowed to have that opinion. The conditional privilege is one where the essence of it is you must show malice, and this has to do with politicians and reporters mostly. They're protected in what they do in their daily jobs because they know they're protected by New York Times versus Sullivan case 1964, which greatly increased the burden on the government to prove that that privilege did not exist, that they were in violation they were doing something wrong, and that's because the reporters did not have malice. The reporters simply show, I talked about that politician, I talked about that reporter without malice. I didn't have malice. That's the test for conditional privilege. You have to show you didn't have malice in order to be protected by the First Amendment. The next thing is commercial speech. Commercial speech is less protected than political speech, and therefore more government regulations allowed. The government can regulate, the government regulation must in any event be legal, they must have strong interest, and it must relate to selling goods and services. That's what the court said. Otherwise, it's okay, it's protected, as long as the government adheres to those tests. Unprotected speech is a category of speech. Unprotected speech, I'm going to talk about simply defamation and obscenity, basically. Defamation is, as you know, libel and slander. And note the New York Times versus Sullivan case, where you're protected if there's no malice. So if anybody is suing you and says you're wrong for what you said, if you show no malice, you're protected. Obscenity is a big area. George Carlin famously defined the 7 dirty words in 1972. Shit, piss, fuck, cunt, cocksucker, motherfucker, and tits. Those were the famous 7 words. Whenever I do this in class, my students say, could you repeat that, Professor? I didn't get it. I said, no. Anyway, in Pacifica in 72, the court let Carlin off the hook and said that, we think fleeting expletives are okay under the First Amendment. And also we think that if you do it between 10 p.m., the court said this, between 10 p.m. and 6 a.m., then it's okay. Miller came up in 73, though, with a little bit of test, and said there's a 3-pronged test. Community standards, prurient interest, and artistic value. Okay, that's the 3 things you look at with obscene speech, or obscene anything, with obscenity in general. And there's the show The Deuce on HBO that just started, and they showed what happened in 1973. When that decision came out, porn exploded in New York City. If anybody's around New York City in the early 70s, it was just all over the place. And DVDs and everything came out at that time because community interest in New York allowed it. Now in Alabama, that wouldn't have worked. You wouldn't have got to the first DVD in Alabama. and you'd be put in jail. But in New York, community standards allowed it. Okay, the last one is fighting words. You can't provoke retaliation, says the First Amendment, according to how it's defined by the courts and the laws, except of course in the NFL, you get away with anything. Hate speech, terroristic threats, fire in movie theater, yelling fire in movie theater, these are all forbidden under the First Amendment. Texas in versus Johnson, 1989, flag burning was okay. The court said you cannot prohibit the manner of expression even if it's offensive and disagreeable. The Board of Education versus Barnett, students not saying the pledge or not saluting is okay. All right, let's get to CPC and Cake Lady. All right, just a quick comment, and I'll leave the First Amendment. These are recent decisions, last couple of weeks, that really just confuse the world, make no sense. Crisis Pregnancy Center, as you know, is the abortion clinic sponsored by the Republicans. They're not abortion clinics. They say they're abortion clinics. They're not. They're pro-life clinics that say they're abortion clinics sponsored by, okay. So California came out and said, wait, you gotta say what you are. You can't say what you aren't. You gotta say what you are. California regulated them and said, you gotta say that you don't have doctors, you don't have abortion procedures, you're not really what you say you are. In the Cake Lady case, you know that, where she came out and said, you can't force me to, I'm able to express my opinion by saying, I don't want to sell this cake to these gay people. Okay, and Colorado came back and said, no, you can't, you have to sell it. These two decisions alone blurred the lines completely between religion and speech. For us lawyers, we're having a hard time figuring it out already. You can't compel speech, I guess is what they're saying. You can't compel speech if it violates religion. And everybody's saying that this speech you're asking me to do or not do, either compelling the speech or not, is against my religion. It's just a common argument now, and the court doesn't know how to deal with it other than allow it. So the CPC case was held up for CPC. Cake Lady won. These people are all winning because it's she didn't say it was a matter of expression anymore. She said it's a matter of religion. I can't sell this cake because of my religion forbids gay people, or my religion forbids an abortion. Then the court found, and the court said very clearly in those cases, you Colorado, you California, you're showing a bias against these people. You're showing a bias against abortion. You're showing a bias against people liking or not liking gays. Okay, but then the court comes back later in the Muslim ban and says, the court found, religious bias by all these states, but no bias by the federal government. And so they allowed the Muslim ban, and they found, the court specifically said, we find no bias against the Muslim religion. And when, we know verbatim, Trump said, we don't want Muslims. But that's where the lines between speech and religion are being blurred now, to the point where we don't know what we're doing. And I'm sure it'll all be very much clarified for us with the next Supreme Court justice, unfortunately. Number 2, right to bear arms. We're moving. We're doing great. A well-regulated militia. A well-regulated militia. A well-regulated militia. Being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay. The history is that the Bill of Rights in 1689 by the English protecting the Protestants from disarmament. That's where it started. Together with objections by anti-federalists to a federal standing army, which we had at the time of the Constitution, led to the debate on this amendment. We have a long tradition of militias in the Revolutionary War, later in the Civil War, and now the state National Guards. Through history, states wanted to protect themselves from the sovereign, from slave revolts, from terrorists and criminals. The framers argued that there's a line between resisting tyranny and mob rule. This was the argument between Madison, Jefferson, all of them. And then therefore the question becomes, well, is there an unlimited right or no right? No, I don't think so. The question is not whether there's an unlimited right to guns or no right to guns. I don't think that's the right question. And I don't think they thought it was either, but nobody knows where to draw the lines. And that's where we are today. Long history of definition and attempts on gun control, as we evolved from 4 million people in 1789 to 322 million people today, in a more complex society where 3 rounds per minute goes to 45 rounds per minute in a 30-round magazine. U.S. Cruikshank case, 1876. The Second Amendment applied to federal courts. The states can do all the infringement they want, but it applies to the federal government. Federal courts, it applies to the federal government. The states can infringe. Then, in 1939, the Second Amendment protections were only in relation to a well-regulated nation. That's what the court said. These protections you see here in the Second Amendment for bearing arms apply only to well-regulated militias. That's the landmark case, Miller in 39. Then what happened? 1967. The Black Panthers stormed the Sacramento Capitol building with weapons held high, machine guns, everything, and took over the state capitol and said it was their Second Amendment right to have those guns and to do what they did. Those are Black Panthers. That is the position of the NRA today. The NRA just stole that. Up until now, up until then, 1967, the NRA was a gun club. You know, they went out target practice. Now, they say, wait a minute, there's more to this than we know. And the NRA became the lobby they are today. 1993, the Brady Act. Again, we're trying to control guns here. This is the best we can do. Even the framers were torn. They didn't know what to do. The Brady Act required background checks in 1993. And then Prince, in 1997, got the Brady Act declared unconstitutional. And they did it with the 10th Amendment, which was really good, really unique, very innovative. Hopefully we get to the 10th. And then the landmark case of Heller came down in 2007. Everybody remember Heller. The right to possess unconnected with militia. Ta-da! Okay, if for traditionally lawful purposes. And the court gave a list. You should restrict mentally ill people and concealed weapons. You shouldn't have weapons in sensitive places, but anybody can have a weapon for traditionally lawful purposes. That's the Heller case, which is still, of course, applicable today. So therefore, as you can see, the Second Amendment is very confusing. Justice Stevens said, and I like Justice Stevens, the right to use and possess arms must be in connection with a well-regulated militia. Well-regulated militia, that's what Justice Stevens said. Justice Stevens said that in his opinion. Justice Scalia said, the people are the militia. So we got him. Justice Scalia was really very good. He said, oh yeah, okay, well the people are the militia. So anybody can have a gun. The liberal and student view ranges from civilian guns outside the military police, no good, liberal view, to restrictions up to student view. The student view presently is restriction on guns, like background checks, assault weapons, banning databases of ownership of weapons, stuff like that, which is really reasonable. The NRA and unenlightened politicians have another view. And there is no restriction at all on limits, including no background checks, no waiting periods, no cellular qualifications, yes, to assault weapons. The NRA headquarters, you should know, it's very important, has across the front of their headquarters the Second Amendment engraved in concrete, word for word.
Second half.
Except for, leaves out the words, a well-regulated militia. Right.
Oh, what a joke.
What a joke. Okay, thank you. All right, we can talk about this later. I'm going to get on to housing of soldiers, Third Amendment. You don't care about the Third Amendment. I know, but you need to know this, the Bill of Rights. Third Amendment, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war unless it's prescribed by law. Okay, least controversial of all the amendments. As a response to the British imposing the quartering acts during the Revolution, where the British could put their soldiers in your house anytime they wanted, they revolted against that, the founders. A lot of cases have been dismissed under this amendment, such as National Guard taking up in prisons, that got dismissed. Rent control laws used to quarter bureaucrats. Somebody challenged that and they lost. But in one case, Mitchell City versus Henderson in 2015 was the best. They found that the intrusions of municipal police officers quartered in someone's house did not constitute soldiers, quote unquote, under the amendment, despite the fact that they had all the same equipment, all the same weapons, all the same appearance, all the same training. They weren't soldiers, the court said. So therefore, you could take over somebody's house to house municipal police. The next case is just my opinion, I don't know. Where's the next case going to come from? The next case will come housing military border patrol on the Mexican border. We're going to see that maybe. Will the government need to conscript housing, or will the National Guard live in tents on the border forever? I don't think so. They might conscript housing. Can the land they are pitching their tents on be taken over under the Third Amendment? These are things you got to think about in the future. Anything can happen now that they've discovered the Third Amendment. The government. Right. Okay, search and arrest warrants. Okay, number 4. My favorite amendment is the one that's being destroyed the most. People are all focusing on religion, Second Amendment, and all that, guns. This is the one being destroyed the most. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue but upon probable cause. My students love this one as well because they're constantly being stopped by police. They're young kids, and the police are constantly abusing them. And they're going, Professor, can they do that? Well, then I have to give this talk to them. Okay, the history is Madison is compromising with the anti-federalist objections to abuses of the British writ of assistance, which is a general search warrant the British used. So they were objecting to that. What activities constitute a search or seizure? An officer's physical intrusion is defined by landmark case, CATS. An officer's physical intrusion into private property or invasion of privacy of an individual or a physical location. In that case, it was a gambling wiretap. The court found was not okay. It was without a search warrant. What constitutes probable cause for a warrant? A reasonable government search is one based on a warrant judicially sanctioned by probable cause, supported by an oath describing the places, persons, or things to be searched. Exceptions to using only probable cause without a warrant, that's only using probable cause to bust you. This is the government we're talking, right? This is what we're protecting ourselves from. These Bill of Rights protect ourselves from despotism, generally. Exceptions to using probable cause without a warrant is based on weighing individual protections against government interests of public safety. Consent searches are okay. As a lawyer, of course, I never give consent to anything. Evidence in plain view is okay. Evidence in plain view. Okay, here's a tip. I'll give you a tip. I got so many stories, but I got to rush. A tip is, whenever I go to a 2-lane highway going in one direction, there's a red light, Route 36, whatever you know. And there's a red light, cops in the right lane, and I'm approaching in the left lane, the light. Okay, I always stop my car behind the rear bumper of the police car. Never do I approach the side of the police car. Okay, because the guy will just look over and find something, I'm sure, in plain view. Even though it may not be, you know, it could be any, I don't know. So I do not do that as a matter of habit, but that's because I'm a lawyer. Exigent circumstances and routine border searches are allowed. Okay, dog sniffing, you all travel. Not on your front porch, whatever the cop says. Wrong. Motor vehicle or bags at the airport is okay because the dog's alerting constitutes probable cause. School searches and stop and frisk. This is the Terry rule in 1968. You all know the Terry case. Police can search for weapons if they do not exceed reasonableness for their suspicions. But then what about profiling? How do you determine reasonableness in profiling? This is the issue. You know, how does he determine, because he's black? Is that the reasonable reason? This is the issue with that. You know, how do you determine this? And there's no rules. We're fighting it. We're fighting it every day. Administrative searches are okay, where there's a long history of pervasive regulation. We have OSHA, FDA, Health Department. These things, you know, these are routine searches. They're okay. they can do their thing. Motor vehicle searches, the ones my students love the most. There's a plethora of case law since the year 2000. I'll give you a couple. Checkpoints, okay, if sobriety is at issue, or to seek voluntary cooperation in an investigation of a crime, not narcotics, in the area. So when the cop stops you, you gotta know your rights. Number 2, search of passenger compartment, not the trunk, although they all want to go in the trunk. To preserve evidence or if a threat to safety only to the cop, including a pat down of the passenger during a lawful stop if he feels he's possibly threatened the policeman. Just say no, Arizona versus Johnson, 2009. Just say no, the Reagan woman, Nancy Reagan. Just say no and get taken downtown. I know it's hard, I tell my students it's hard, you don't want to go downtown. But when he says open the trunk, you got to say no. He said, I'll take you downtown. And you say, take me downtown. Whatever you got to do. Because it's just I'm protecting my rights, and of course they'll take you downtown. You'll leave within 15 minutes, but the whole going downtown and back took an hour. Vehicle in your driveway, not okay. They can't search it, okay? Don't let them tell you they can. When you're on the road, I tell my daughter, I tell everybody, when you're on the road and the cop stops you for whatever reason, your taillight's out is the common one, just roll down your window like 2 inches, okay? That's what I drill into my kids. Roll down the window 2 inches. Hand them your registration and your driver's license or whatever. Lock the doors. Roll down the window 2 inches. And then that's it. And talk to them through the crack in the window. It's all you can do to protect yourself from the police. I know, I tell my students, your mother told you, your teacher in 5th grade told you, the police are your friend. I don't mean to say they're not in all cases, but you gotta be careful. There's a couple of things recently, I just made pencil notes. Need warrant for cell phone search. The search incident to arrest, they go to your cell phone. They need a warrant for that, for your cell phone. 8 U.S.C. 1357, remember, not just courts, laws too, says that they can search electronic devices on the border without a warrant, without probable cause. That's a law they passed. The last thing I'll mention on the laws recently is everybody should be aware of the Patriot Act, now the USA Freedom Act, and they destroy your Fourth Amendment rights, those acts, simply for the purpose of destroying. It blows up the Fourth Amendment, those acts, and you all voted and paid for them. So I don't know, gotta live with it. That's what we have. What do you do about a violation, in this case, of probable cause? The exclusionary rule is what you should know. The words exclusionary rule, Weeks versus U.S. 1914, provided that a violation of the Fourth, the evidence obtained is not admissible. It's fruit of a poisonous tree. So you have the exclusionary rule, then after all, you gotta go to court, you gotta go downtown, you gotta do all that, but you won't be convicted, but the police know that, by the way. I mean, the police know all these rights. I'll get you in the Sixth Amendment. And they know how to get around it. Okay, we're doing great. Fifth Amendment, rights in criminal cases. Okay, I ask my students all the time, self-incrimination, what amendment? You have to know that. I asked the waitress in the restaurant who's a college student, self-incrimination, what amendment? None of them ever know the answer, but everybody should. You just can't self-incriminate yourself. But rights to criminal. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment by a grand jury. Nor shall any person be subject to the same offense to be twice in jeopardy. Nor shall he be compelled in a criminal case to be a witness against himself. Nor be deprived of life, liberty, or property without due process of law. Together with the 14th, very important words. Nor shall private property be taken for public use without just compensation. Originally presented by James Madison. Much of the content was adopted from an existing common law that was codified in England in 1647 and brought here by the Puritans. This Fifth Amendment presented a personal challenge I'll share with you when I went into the military, and in 1969, the court in O'Callaghan reported that military are denied these rights under the Fifth Amendment if you're in the military. I almost quit over that, but I didn't. Just tried to stay out of trouble. So military people aren't allowed this, they give up this Fifth Amendment right. Grand jury, common law institution, courts today have defined imprisonment for over 1 year as infamous. Exclusionary rule does not apply. Exclusionary rule does not apply to grand juries. You go before a grand jury for any reason, you're busted. The prosecutor gets anything he wants on the basis of anything he says or does, or any evidence he thinks he has. So grand jury, tough. You'll get indicted. And very seldom don't you. Double jeopardy, prohibitions, everybody knows, subsequent prosecution after acquittal, subsequent prosecution after conviction, subsequent prosecution after certain mistrials, multiple punishments for the same indictment. These are all not allowed under double jeopardy. In Heath versus Alabama in '85, they said 2 different states can prosecute the same person for the same act. 2 different states. So you can go to jail in 2 different states. If, you know, if one's Alabama, you go for life, and if it's in New York, you go for probation. Okay, so that's where you get busted. Self-incrimination is defined as the right to refuse to answer any questions, plead the fifth. We all know plead the fifth. As a privilege against compelled self-incrimination, which is opposed to the traditions we have in this country from the 16th and 17th century, where we came from, when we were all immigrants, until we got rid of it here, because we were against the despot, the ruler, causing us to swear oaths to him, or be considered guilty of a crime. Also torture. We were against torture. They tortured people to get them to admit to things. This was in response to that. We're trying to get rid of those practices. Defendant cannot be mute, must explicitly claim the protection. Interrogation by an NGO or SRO, like the NYC or something, is not protected. Corporation is not protected, but sole proprietors are. IRS tax return amounts are not protected, but source of the funds is protected. Civil cases, adverse inferences can be drawn. In a civil case, not a criminal case, adverse inferences can be drawn by someone pleading the fifth, by someone not speaking up. In a civil case, that can be, they can draw the inference you're guilty. In a civil case. Miranda versus Arizona 66, no coerced confessions, confession suppressed if he's not advised of his Fifth Amendment rights. Due process. And I told you it'd be a roller coaster, summertime, right? We're all going fast here. Due process, essentially a person, did not say citizen, will receive a fundamentally fair, orderly, and just judicial proceeding. Explicitly applies to states through the 14th Amendment and equal protection. There's procedural and substantive due process. Procedural due process is the rules for enforcing the law, arraignment, jury, trial, etc., that everybody gets. Substantive due process, the government must have a proper purpose before they take your life or liberty. US v. Windsor in 2013, SCOTUS struck down DOMA under the Due Process Clause of the Fifth Amendment, Defense of Marriage Act. And they said the federal government had no legitimate purpose to deny substantive due process and equal protection to persons that want to marry of the same sex. Taking private property. The feds and states have the power of eminent domain, Latin for supreme lordship, existing in common law as the power of the government to take property for public use. There must be public use and there must be compensation. That's the 2 tests. Public use is benefit the public and welfare, roads, utilities. It's getting crazy these days though, because in 2005, they extended private developers the ability to exercise eminent domain over somebody's property because the private developer said it'll increase taxes if I build here. The court allowed that. It's crazy. Just compensation, fair market value for the property at the time of taking. What is the value of one's view of the ocean who lives on the Jersey Shore. I mean, it's an issue we haven't settled yet. And they're arguing Fifth Amendment, taking private property, and they're protected by the Fifth Amendment, which is what's holding it all up. I had property in Route 81 upstate New York in Parrish, and they ran the 81 highway through my property. I had like 25, 30 acres, and they ran the highway through there, and they took like a whole bunch of my property, you know, acres and acres and acres of my property for the middle part of the highway, for the traffic going two different directions, because it's a major superhighway, and they took the middle part from me, and they paid me nothing, you know, a few dollars per acre. But it turned out I had hardwood ash trees, ASH trees on that property. I found out later that were worth a lot of money, but they don't do that. You know, what does it mean then? My point is, what does it mean? Just compensation. Okay, everybody learning stuff, right? Or does everybody know this already? I'm boring you. If I'm boring you, tell me. I can't tell. I know this stuff, so I don't know. I don't know. Okay, but we'll continue.
It's a summary sheet.
I know, here, I'll copy this if you. I know, it's a lot. But that's okay, it's just an introduction. You don't have to walk away with all the knowledge. Okay, 666. We're up to Amendment 6, I'm so happy. Rights to a fair trial. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Big, big amendment. The history on it: at the time of the Constitution, English courts were controlled by the king. And his lords, together with his lords, they had all the bias in the world, and the abuses were unimaginable. The framers wanted to protect individuals from the government. And this amendment made American courts people's courts, as they said, the framers. We'll make them people's courts. Okay, we're going to go through these things in the thing real quick. A through G. 5, 6, 7. Speedy trial. Wingo in 1972 defined a 4-part test for speedy trial: length of delay, reason for delay, time and manner, prejudice. Or else the case is dismissed. Now, I know you all people are not criminals here, and you're all not expecting to get arrested in the near future and stuff. This stuff is really, really important to a lot of people who get arrested constantly. And it's a very helpful thing. Public trial. Court ruled in 1966 that public trial is not absolute, where publicity undermines due process. And in 1986 ruled it can be closed at the government's request. So no public trial there. Impartial jury. English juries had 12 members, unanimous verdicts. Pretty much the same today. States can have 6 members, and less than unanimous in the states. Voir dire, everybody knows voir dire, where the lawyer eliminates people from the jury before the deliberations, before the trial starts, and that's part of the protection here. And vicinage, the venue where the trial is heard, is part of the protection here. Impartial jury. Bill Cosby can't get a good goddamn jury in LA. He's got to go to like Colorado or someplace where they don't watch TV. So, you know, I mean, where do you find a vicinage, a venue where you can get a fair trial? Notice of accusation, indictment required, vague wording not allowed. Confrontation, origins in the common law about hearsay. This is where hearsay comes from. You can't use hearsay. Origins in common law hearsay requires credibility through cross-examination. A plethora of cases on what testimonial are in the court reporters. A lab report not allowed unless a technician testifies as to the lab report. A dying declaration or emergency utterance is allowed without confrontation. For instance, your mother's being the last utterance from the guy who's dying. My mother shot me. Is not allowed. Is allowed against his. Well, I shouldn't say mother. That's not nice. Everybody loves their mother. Everybody loves their mother. Whatever. Joe shot me. Okay. All right. That's allowable. This is dying, and he died. Last breath. Joe shot me. Okay. So Joe, you know, so he's not around to give that testimony. It's really kind of hearsay, but it was a dying declaration, so they allow it. Compulsory process. Defendant right to compel witnesses, identify witnesses to be known. Assistance of counsel. Everybody knows this one. Defendant has a right to a lawyer. Gideon versus Wainwright, 1963. Counsel must be provided to indigents in all felony cases. Brewer versus Williams, 1977, says the defendant's right begins with interrogation and arrest. Self-representation, pro se, as we call it in Latin, is allowed unless courts deem the defendant incompetent or to waive his right. Pro se self-representation is not allowed in appellate courts under any circumstances. So Miranda versus Arizona, just remember, 1966. Miranda warning. You see it on your cop TV shows all the time. Miranda warning. The right to remain silent. Protection of 5th against self-incrimination, and 6th, right to counsel. Evidence obtained without custodial warning is inadmissible at a criminal trial. You know, fruits of a poisonous tree. It's subject to the exclusionary rules. You're all becoming experts now. You know I can use these words. You know what they mean. Believe me, police interrogate the hell out of you and don't care. And they know it can't be used, and they don't care. They're just going to interrogate and try to get information. They just don't care. They'll find other ways to get it once they decide what they have everything they need to know. So you got to be really careful. I mean, nobody can really be quiet. You watch enough TV. Nobody can really be quiet when they send that Haggerty woman in. God, she's good. I don't know. She's really nobody who's not going to talk to that Haggerty woman. I don't know her first name. Huh? Mariska. Mariska Haggerty. Yeah, she's really good. Okay, 7. You're doing good. In suits of common law where the value in controversy shall not exceed $20, shall exceed $20. The right to trial by jury shall be preserved. No fact tried by a jury shall be otherwise re-examined in any other court, and according to the rule of common law. History, authored by James Madison in response to anti-federalists. They wanted to guarantee a jury trial in civil cases. So this is 7. Okay, we talked about 5, we talked about 4, we talked about 5 with criminal cases, we talked about 6 with criminal cases. This is 7 now. They say, well, we want it in civil cases too. So it provides for a trial in civil cases to avoid, giving judges and the government too much power. The amendment has never been applied to the states. Never. But states have voluntarily followed it, generally. Common law versus statutory law. Common law began in 1215. I always ask my students what happened in 1215. Michelle, you know what happened in 1215. Magna Carta. Yeah. And laws of England, and subsequently determined by the laws of the states, judicial decisions and culture. Statutory law is the legislature. It's federal and state governments passing laws. That's statutory law. Civil versus criminal. Civil, the results of civil trial are compensation and equity. Okay, the results of a criminal trial, what's the government seeking? Punishment and deterrence. Deterrence, however you say it. Punishment and deterrence, they both are used to deter malfeasance, just their results that they seek are different. The appeal procedure, cases on appeal re-examine, cases on appeal cannot re-examine the facts of a case. On appeal, when you appeal a case, it's only on the law and the application of the facts as they were brought out in the trial, the original trial, that are presented to the appeals court. That's it. And that includes everything. I mean, Supreme Court does the same thing. Supreme Court, when they do a law today, the trial court facts are the facts. They just take those and apply the law to them. They don't do new facts arguments before any appeals court. Federal jurisdiction today, over 75,000 in diversity. Diversity is 2 people from 2 different states. A federal question. Natural, federal question. Freedom of religion, federal question. The amendment does not apply or guarantee trial for maritime, patent, or suits against the government, as derived from English common law. These are specifically and exclusively reserved in Article 3 of the Constitution. So they do not apply under the, not that anybody here is going to be involved in an admiralty case, maybe a patent case. They're resolved under Article 3. Okay, number 8. Bails, fines, punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's 8. The history is identical wording with the English Bill of Rights of 1689, advocated by Patrick Henry and George Mason of Virginia. Okay, excessive bail, what's it mean? No figure higher than reasonably calculated to prevent flight, or excessive in light of the evil. There is habeas corpus, which we all know, that prevents any abuse of holding someone without bail or excessive bail. He can then exercise his right to habeas corpus, which is to get out of prison to argue his case. It's kind of like forces bail. Excessive fine, Waters Pierce Oil, 1909, defined grossly excessive fines and fines disproportionate to the crime constituted deprivation of property without due process of law. In accordance with the 5th and 14th, the courts then set standards and guidelines for what fines should be. And they do that today. Cruel and unusual punishment. I know that's the one you want to hear. Cruel and unusual, because the Supreme Court has forbidden some punishments entirely, and other punishments as excessive when compared to the crime, or compared to the competence of the perpetrator. It's applied to the states through the 14th Amendment, as is every Bill of Amendment, as every original Bill of Rights is applied to the 14th. Furman versus Georgia, landmark case, principles of cruel and unusual. Cannot be degrading of human dignity, especially torture. Cannot be obviously inflicted in wholly arbitrary fashion. Cannot be clearly and totally rejected throughout society. And cannot be patently unnecessary. Punishments forbidden regardless of the crime. Regardless of the crime. You cannot do public dissection. You can't burn someone alive. And there's no death penalty if you're under 16. Death penalty is forbidden for rape without murder, or excessive punishment forbidden for certain crimes, like alcoholism, so long as it's not public. Firing squads are not cruel and unusual. I'm talking from legal cases now, without citing them. 50 years for stealing $230 is okay under a 3 strikes law. Life sentence without parole for possession of 1.5 pounds of cocaine. Life with parole possible for shoplifting $150 in videotapes. And that's where the courts have come on that. That was obviously an Alabama court. Sorry, Alabama. Who's from Alabama? I'm so mean to Alabama. It's my favorite state. Oh dear. Okay, number 9, rights retained by the people. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage rights retained by the people. History. This amendment does not confer substantive rights like the other ones do, like against self-incrimination or whatever. Anti-federalists were simply worried that if some right or power was not specified here in the Constitution or Bill of Rights, then it would revert to the federal government. They didn't want that. The 9th then was put in and intended to vitiate the long traditional concept in the common law of expressio unique and exclusio alterius. The express of one thing excludes all the others. That was commonly accepted in common law. So therefore, you can't and therefore not deny fundamental rights not enumerated. So in other words, the 9th Amendment says that if it's not enumerated in any other amendments, doesn't mean we've given it up. Doesn't mean we wavered it. It's still there. We just didn't know it when we wrote the first 9, first 8. This is number 9. This is similar in logic to anti-waiver provisions, as you know in business. You have an anti-waiver, so I'm not waivering something if it's not in the contract. Okay, that's what business people put in their contracts, anti-waiver provisions. Okay, the courts have held that the first 8 amendments do not exhaust fundamental rights, so that the 9th Amendment becomes an independent source of right protected from infringement by the federal government and through the 14th Amendment of the states. Griswold versus Connecticut, everybody knows that, came out of the 9th Amendment in 1965. The right to privacy is not enumerated, but within the penumbra of the Constitution. It's not specifically, the right to privacy is not mentioned anywhere in the in the Constitution. So they used the Ninth Amendment to prevent the government's intrusion into the privacy of a marriage's use of contraception. Okay? Ninth Amendment, Roe versus Wade. I don't know if everybody knows this, but it's not commonly known. And they found a woman's privacy as to abortion as the basis for Roe versus Wade under the Ninth Amendment. So that was in '73. I mean, this is very, very current constitutional interpretations, all about to change. States have argued that the Ninth should not be used as a weapon of federal power to prevent state legislatures from passing laws they think appropriate. So they specifically said the Ninth can't be used against the states. If they want to do something, they have to be allowed to do that. It can't be used as a weapon against the states. The states are allowed to do what they want to do if it's not otherwise enumerated. Just like people, unless it's otherwise enumerated, they can do what they want to do. Unfortunately, the states lost. The states lost in Griswold and Roe. Because if the states were allowed to do whatever they wanted to do that wasn't otherwise enumerated in the Constitution, the states would have won Griswold and Roe. So they were denied that right. The new court, of course, as you know, is subject to a lot of controversy. I won't go into it. And what they're going to do, especially if they have a 40-year-old woman who's got 7 kids. Number 10. I'm not being political on that. I shouldn't. Number 10. We're good. We got 2 more minutes. Powers retained by states and the people, the powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states, respectively, or to the people. I mean, like I said before earlier in our conversation, this became very important. Nobody even heard of the 10th. What the hell's the 10th? The history is the purpose and thrust of the Bill of Rights was embodied in the 10th, meant the rule of construction and a reaffirmation of the nature of federalism embodied in the Constitution. It's considered a fundamental basis for freedom by limiting federal power. So it says the powers not delegated to the United States are reserved by the states, the individual states. Adds nothing substantive, only proposes a truism that all is retained and is not surrendered. The Anti-Federalists wanted this amendment in 1789, so the federal government must not be able to dictate to the states. It's been inactive until very recently, and we know, as I told you before, in 1998, the Brady Act was found to violate the 10th Amendment by requiring the states to conduct background checks on persons forced to implement gun control. And they overturned the Brady Act. The NRA was on the other side of that case. 2012, Affordable Care Act violated the 10th Amendment as coercive by the federal government, forcing states to expand Medicaid. So these are really big, big decisions recently we've had under the 10th Amendment, which nobody ever heard of before. The Commerce Clause enforced through the 10th and 14th includes violations of interstate commerce, setting state wage laws, DEA on cannabis growing, Lopez case, 1995, legitimacy of federal gun-free zones. And that case did limit federal it did establish gun-free zones, but then it was later struck down by the NRA. Today, we are in an age of cooperative, what I call cooperative federalism, where the feds encourage the states to implement national programs on condition of federal funding. Speed limits through highways are established by the federal government. Otherwise, we don't pay for your highway. Education aid, anti-abortion tax incentives. These things the federal government is controlling the states through the use of money. It's called cooperative federalism. That's what they call it, the government. Of course, the framers of the Constitution didn't want this kind of power in the federal government. But money talks. Okay, last. And then we can open it up to, I have handouts later when we leave. Yeah, just pick one up if you want. Late recent articles and stuff, about the churches in New Jersey not getting taxes for repairs and things like that. Stuff I haven't had time to talk about. A lot of it's there on the articles if you want to grab one. 14, civil rights. All persons born, I'm talking about 14.1, because without 14, we have no 1 through 10 at the state level. That's it, simple as that. Federal level, yeah, but not state level, and of course states need to have 1 through 10. All persons born or naturalized, not interesting, all persons born or naturalized and subject to jurisdiction are citizens of the United States and of the state within they reside. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, property without due process of law, nor deny to any person within its jurisdiction equal protection of the law. 14th is applied everywhere today. When you read the court decisions when they come down, they say this is a violation of the 5th Amendment as applied to the states of the 14th Amendment. You know, they always say that, as applied to the states of the 14th. 1868, the history. 1868, the states within the defeated Confederacy were forced to ratify the 14th Amendment to regain representation in Congress. If they didn't ratify the amendment, that's how it got ratified, then they weren't allowed back into the United States, into Congress. Today, it's the most litigated part of the Constitution, motivated in response to Dred Scott decision in 1857 was the original motivation for this amendment, holding that descendants of African slaves were not citizens. That was the Dred Scott decision, and that's what prompted this 14th Amendment. New Jersey ratified the 14th Amendment in 1866. They rescinded it in 1868, and then re-ratified the 14th Amendment as late as 2003. I mean, you're all from New Jersey, so I found that pretty interesting. Okay, ABC. A, privileges and immunities. I'm just going to tell you what it means. Shall not be abridged for citizens. Court does not define Native Americans as citizens or with these rights until 1923. Courts have ruled very recently on birth, quote unquote, birth tourism. I hope you all kind of got an idea what that is, as a method to gain citizenship. So in other words, to get, you come over here and you have a kid real quick and that kid becomes a citizen, and then you go back to wherever you came from. So you could come over pregnant and do that on a 6-month visa, and that person's a citizen. That's birth tourism as a method. The courts have recognized that as okay. Due process, substantive due process has to do with labor hours, wages, marriage, abortion, all these things the states want to get involved in. They have to adhere to due process, both substantively and procedurally. They have to have notice, representation, neutral decision makers. The states have to have these things now that they didn't have before. And lastly, most importantly, equal protection of laws. All persons without due process of law, shall any state life or liberty without due process of law deny, nor deny to any person. See, it's funny, they come and they say person. They don't say citizen. The last sentence says, nor deny to any person within its jurisdiction equal protection of laws. That's kind of important down the border right now. Think about it. Where people are, according to some of our leaders, not entitled to due process. Anyway, equal protection of law. All persons are treated the same. 14th Amendment includes anyone within a state's jurisdiction and extends itself into the 5th Amendment due process of persons to apply to all persons. Court defines standards. There's 3 standards in applying equal protection. There is strict scrutiny, they call it. No discrimination at all, under any circumstances, on the basis of race, or national origin, religion, gender, including LGBTQ. Same-sex marriages, no discrimination, strict scrutiny. They were very specific about that. And then they said there's intermediate scrutiny. Substantial government interest, the court said, is necessary to discriminate. And this is important because it's areas right now that are being litigated everywhere. Affirmative action, gerrymandering, free public education. These things are all in the courts right now and being affected by the government now. And that's just intermediate, substantial government interest, which is not hard to establish by the government. And then rational basis is the third, justifiable government interest for any discrimination. Okay, we're gonna go, I'm gonna ask people, I'm here for one reason, and that's to get your comments and stuff, because I learn, and I'm here to learn. I give this talk all the time, I don't need to learn from this. I need to learn from you. So I'm gonna leave it now, I'm just gonna say one last thing. I'll leave you with this thought to take home. The word democracy does not appear anywhere in the Constitution. So just keep that in mind. Everybody throws around that democracy word. It has no meaning under our Constitution. Okay, thank you very much.
Okay, so we have a little time for questions. You have a question or?
I have a question.
Oh, okay. So I'm gonna bring the mic around. So the mic is not only for amplification, but it's also to give permission for the person holding the mic to talk so that we don't have multiple people talking at once. So wait for the talking stick to come to you.
Do I have
I'll
to
make
answer these
sure-
questions?
I will make sure that everyone has at least one time with the mic.
Yeah, I know, that's why I'm moving over here. Thank you for the talk, it was great.
Thank you.
If through the Constitution and the Bill of Rights and the 14th Amendment that it's fair and equal and everybody has those rights to trial and due process, in your opinion, why is the legal system not fair or unfair in between rich people and poor people? Why do rich people appear to have more rights than poor people? Why is the legal system biased against poor people?
Why is the legal system biased against poor people? That's a real leap. I don't know that I've encountered that. It's a good thought. I mean, you know, you talk about stop and frisk, and you talk about arresting people and staffing our prisons with prisoners. Sure, poor people are represented quite a lot more. They theoretically were afforded all the same rights. Every right I talked about today applies to everybody the same. Okay, maybe they couldn't afford as good a lawyer? Could that be the difference? I'm trying to think. Maybe somebody else can help me, but I think that you know, there was never, everything I'm thinking, there's never a distinction between poor people, rich people, in any of the court cases, in any of the laws or anything. It applies to everybody equally who's a citizen. I just think that, you know, in this country, as racist as it is, for instance, you're going to find police arresting more black people and depriving them of their rights, and they can't afford a lawyer, and then they can spend all their time in jail. I mean, bottom line. I don't know. Somebody else can help me there. I can't answer it.
The whole purpose of the Constitution, the federal Constitution, is to protect the minority
Right.
against government authority. So it limits government. That's the whole point.
It's supposed to limit government, despots and stuff. That was the framers' intention. It didn't, but it's still confusing because, you know, the Second Amendment was passed so they could control the slaves, is what the framers were thinking when they did it. So, you know, the thinking is changing all the time. But you're right, the essence of it is to control despots, and it is to protect the people that can't protect themselves for the most part. And I think that's the best we can do.
I got two quick ones. The Border Patrol, are they acting in violation of the Fourth Amendment if they go out of their jurisdiction? As far as, they can act within a 100-mile radius, a
Right.
100-mile detaining people,
Right.
and stuff like that. What if they go outside of their border? What if they're over the 100 miles? Are they violating the Fourth Amendment? The Bill of Rights?
Well, no, they're really violating a statute, really. They're really violating a statute. The statute was passed under the Fourth Amendment, and it's legal for them to operate within the 100 miles. They're not operating within the 100 miles, so they're in violation of the statute. So it's a false arrest, it's inadmissible, the person can't be held in jail, you know, because it's against the law.
Right, because of the immigration crackdown, they're doing a lot
I know,
more.
they're doing, and for the most part, like police, when they interrogate you, when they bring you downtown and stuff, they get away with murder. You know, they get away with this. What's the person gonna do? The immigrant Mexican who can't even speak English and has no money or anything, what are they gonna do?
Right.
They're not gonna do anything. anything. They don't even know about the Bill of Rights or anything, or Fourth Amendment or anything. So, and the Border Patrol knows that.
Right.
So it's really kind of almost, I hate to say it, a moot issue.
And the George Stinney case from 1940, the black boy that was arrested in South Carolina for the two murders, that case was overturned. Was there a violation of his Eighth Amendment? Because he was executed for the murders, which was overturned 70 years later. He was 14 years old.
Yeah, and he was executed because the law, the interpretation that the court, I'll look it up, but the court case, which specified the rules for cruel and unusual punishment, were after that.
Or after that?
Yeah.
Okay.
And probably in response to that, who knows?
Thank you.
And 16 was the age. 16 was the age that the court agreed to.
Article 1, Section 8 defines the powers of the Congress, right? And in there it says Congress shall have the power to, words to the effect of create and maintain a militia, that the states shall have the power to appoint officers of that militia. That sounds like a pretty far cry from Mr. Scalia saying that we're all militiamen. I mean, it just seems like it almost seems like a violation of the Second Amendment when you take out the militia business. Now, back in the day, the Green Mountain Boys of Vermont were a militia, Paul Revere's Ride. What the hell is a militia today?
Well, I don't know, the Black Panthers, are they a militia when they raid the state
Well,
house?
that's what I'm asking. I don't understand what that means,
Right.
you know?
Well-
But, I mean, we have this article, we have Section 8 of Article 1 that's defining militia.
Right, well, the courts have to define what militia means. First, they have to define if militia is important, which they've been back and forth on. And sometimes they just disallow it. Militia means nothing. And then other times they say what militia is or isn't. They try to define it in terms of what it is. And they've defined it in court cases as National Guard and formal organizations. They've never defined it as informal organizations. So the militia, and when Scalia says the people are the militia, come on, I just gave that to you as a little toy to play with because I mean, it's ridiculous. I mean, Scalia's being political. He started this whole political court stuff. Scalia was one of the first to become this blatantly political. And that was simply a political statement. So
Now,
it's not true.
It says to bear arms, it doesn't say firearms. Can I own a surplus army tank that's fully functional? Can I walk around with a gallon of sarin gas?
No.
I mean, what the hell are arms anyway?
They're whatever the government says they are when
Yeah.
they arrest you. And you have to go to court and try to argue, well, I have Sixth Amendment right to this tank. And, you know, you're not going to win.
Yeah.
You're not going to win. I know, sorry. It's bad news, sorry.
Thank you so much for your talk. Regarding the poverty, Stephen's question, there's a myriad that can go in forever, but Murder on a Sunday Morning is a wonderful documentary I recommend to everyone. And it talks about how a young black boy was railroaded through the system.
Right.
And it's brilliant. The other thing
Thank you for that. I mean, it is true. I mean, there is a distinction between rich and poor. Don't get me wrong. It's just I'm trying to say within the Bill of Rights, do they make a distinction? Never, no place.
My question for you is your comments on ERA and if you find it important to pass the Equal Rights Amendment for women.
Well, of course, it's just my opinion, though. I mean, of course. I mean, of course it is. Could it pass? Yes. I mean, you just need the state votes. I mean, you need. I mean, that's an amendment. That's an amendment to the Constitution. I mean, you got to have all the states on board, and that's been the problem. I mean, they're just not ever going to admit that women or black people or anybody are equal. I mean, they're just not going to do it. And half the states in this country, probably. Yeah, that's the problem. Try to get that passed.
Take over the legislature.
Well, yeah, that's happening. But the problem is now they're saying they're socialists and stuff. And I don't know how that's going to go down with the public. I don't know. Because everybody doesn't like that word socialist. You know, I mean, we know better, but I don't know. Women need to take over the legislature. Absolutely, I agree.
Good morning.
Yeah.
Churches aren't to be taxed because religion isn't to be infringed upon.
That's right. Free, yeah.
And how is-
Establishment clause.
How is taxing them infringing?
Oh, because it's a burden. we're causing them to, and Trudy, you can answer this if you want.
Businesses bear the burden of taxes.
Well, no, I mean, if the church has to pay taxes, then you are maybe taxing one religion more than another, or more, in one area more than another, because of the tax rates, the financial burden on the churches, it's the state. Basically, taxes are imposed by the government. And the government has said, I don't care what it is, taxes, schmackes, I don't care, property taxes, whatever, I don't care. It doesn't matter. You are the government, and you're not allowed to dictate to churches. Again, it's against the Establishment Clause of the Constitution. So you can't.
Have there been,
Go ahead, I just heard it though.
have there been cases where local or state governments have attempted to tax churches or other religious institutions, and that's been challenged, or is it just the government has laid off without it being?
Yeah, we're a really religious country, and there's a lot going on between the governments and the churches, locally, nationally, and you know, it's a matter of challenging it, and the ACLU can't challenge every one of them. In New Jersey, just recently with the repair of churches, somebody did, the ACLU did step up and challenge it and said you can't pay tax money to help repair churches, which is what the town was doing.
No, I'm thinking about the other way. Taxation of religious organizations, has that ever been?
Never.
So it's
No.
not settled in the courts at all, it's just?
No, not settled in the court. I mean, the courts have come out to the Establishment Clause says you're not allowed to tax religions, right? And you're saying what? Have the religions ever been taxed? Is that?
No, I'm saying, has there ever been a case where the courts have actually issued a ruling saying you can't tax
Probably.
religion?
I don't have it in my list, probably. But it wouldn't need to be. Since the courts defined in the cases I gave you today, they defined the Establishment Clause and in the cases, and so I don't know if it's even ever come up. It's clearly defined, yeah.
Okay, hang on.
Sorry, you do it. Used to my students, yeah.
I wanted to know about there's a new amendment with respect to women. Women aren't human anymore.
Equal Rights Amendment for women, right? Yeah, that's not passed.
Well, what is the nature of the amendment? Why are women not human? Or
It's a good question. It's a really good question, you know, because like people are standing up and saying, what's the issue? You know, they can go to the grocery store just like me. You know, I don't know. I mean, you know, people say that with that amendment, there'll be equal pay, there'll be equal, you know, I mean, they got the right to vote, fortunately, but, you know, there'll be all these other equalities, equal opportunities. That's what they say if they have that amendment. But then everybody's saying, but, you know, they have those now. If they don't get equal pay now, it's because they're not as good as the man.
what does the amendment say?
Oh, I don't know the nature of the words of the amendment. It's not been passed. No, I don't know the name. I don't know the words.
Does anyone, hang on.
Anybody know that? Yeah, Google it. Yeah.
Yeah, the words,
have it?
it's a very short,
Trudy has it.
go ahead.
Trudy, what is it? Read it.
I just Googled it.
Yeah, okay. Right, okay, so equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And then second clause, the Congress shall have the power to enforce, oh, well, that's just in, yeah, okay, so it's basically.
Yeah.
that
Okay,
first
so it's
sentence,
not,
the
we
sub-
call it women. It's not really women. It's just no discrimination on the basis of sex. But the other problem I have with that is we have the 14th Amendment. So, you know, if I was a woman, I'd be arguing and suing all over the place just under the 14th Amendment. And I probably could. I don't know if we need a separate jurisdiction, a separate amendment for it. But I'm all in favor of women's rights, and the amendment can't hurt, can only help.
How does the First Amendment apply to us as humanists?
Well, they said, I read the case, it doesn't, they said very specifically, the court, you cannot discriminate on the basis of religion or irreligion, IR religion,
Well,
and
yeah, but-
non-religion.
But if I
Atheist, humanist,
refuse to bake a cake for a Christian because of my religious
yeah,
beliefs.
it's fine. You're fine. Under the cake lady case, you're fine. Because it's against your religion. Gay people are against your humanist religion. And you can't serve gay people. That's the same argument that the cake lady made. It's fine. It's fine.
I have a question about the First Amendment. one of the exceptions that you didn't mention there explicitly
It's probably a
is,
lot.
well, one of them is, I mean, there's the child sexual abuse. There's the you can't yell fire in a crowded theater. Another one that's very specific for foreigners is that with respect to contributing to candidates, foreigners are not allowed to do that. Yet their First Amendment right is protected. We can go look at BBC, we can go look at on the internet, or we can read Financial Times in this country. We can go to the Russian website and look at all the Russian government's views on anything, or Iranian government's views on anything. So there doesn't seem to be any restriction with respect to the First Amendment rights of foreigners, except when they give money to our candidates for office. That's explicitly prohibited, just like you don't have a right to sexually abuse a child. So why would that exception be? I mean, we as American citizens can contribute anything we want to any candidate we want. So that's our First Amendment right. And it seems like BBC and all the other foreign entities have all these First Amendment rights because they can publish here and everything, except for one right. They can't contribute to a candidate. That right is denied to them, but every other First Amendment right they seem to have.
I think I can answer that.
Yeah, go. You got it.
The answer to that question is the equation that money, that contributing to candidates is a form of speech, is a very new concept that was just recently invented
Citizens United.
in Citizens United.
Good.
Another court decision could start to apply that precedent to foreigners donating to presidential candidates, but that has to work its way through
But they
the legal system.
exclusively already put it in that sentence.
But it hasn't been litigated,
They
is what he's
said,
saying.
but the Constitution said, the people who made that decision said this doesn't apply to foreigners. It's in that decision of Citizens United. It says, if it's a foreigner, you can't give money. That's an exception. He put that in the decision.
In the majority
It makes
opinion.
sense to me.
Right, it just has to be litigated. Nobody's litigated it, nobody's brought it up. It's a case that needs to be overturned. Everybody says that. It's wrong in many ways. But, that's all. Nobody's litigated that point. I mean, Putin is donating every day. Right.
No, just say.
More procedural. Will you be around for a while to ask questions privately?
Sure.
Okay. That's all I.
Sure. On obscenity, I'm sure, right?
No.
I understand. You can't do it in public forum. Only I can say those words.
Thanks for a great talk. Whose rights are these? Is it people? Is it citizens? Is it residents?
It varies.
Is it competent? Is it BBC broadcasting in? I think there's a lot of boundary cases.
It varies. In the Constitution, one amendment will speak about citizens only, and another one will speak about persons. It varies all the time. I can go through each one and show you individually. I brought it up in my talk in some instances where it says persons or it says citizens. Like I had the problem with the border control because it says persons, equal protection, not citizens. And so even though they're not citizens, they have the protection. So I think that, it varies by amendment, and you have to look at each amendment you want to apply in terms of whether or not it's applicable to you as a citizen or a non-citizen. The essence of it all was to protect citizens. The essence of it all was to protect citizens against the government and despotism, in general. But then they do talk about persons in many of the amendments. It's the best I can do without going through each one.
As far as this woman's issue is concerned, I think that, in my opinion, the third article talks about the Senate, there's 2 senators from every state, is that correct?
That's Article 1, that's the legislature.
There's
Right.
There's 2 senators from every state.
Right.
I would make a change that one of those senators from every state, since there's 2 sexes, one has to be a woman. That's where I would make the change.
Well, good for you.
That would get it.
I wish you a lot of luck. I wish you a lot of luck with that one. You know, you have to vote. Yeah, you're telling people how they have to vote, right? Good luck. You know where that goes to? That goes to despotism. When the government starts telling people how they must vote. How you must vote for a woman, you must vote for a man. And the government can't do that.
We already have that in New Jersey.
That's not what she said.
In New Jersey, they have what?
We have that. Your committee people has to be a woman and a man.
The committee people.
That's party controlled though, it's not.
Right, that's a party thing.
That's a party organ.
That's just a simple
Yeah,
club.
you wouldn't have that to say one council person has to be a woman, one
Yeah,
council
no, that would
person.
be terrible. I mean, that would be terrible precedent. I mean, yeah, I agree, you know, there should be 50-50, and I agree with you, but it would be a terrible precedent to establish, to order people how they should vote. It'll come back to bite you.
Okay, well,
It's like when I went to law school in the first year, the constitutional law guy stood up and my professor, and he said, like, you know, I mean, they got these Nazis going down the streets of Chicago, protesting and everything. And it's fine. And I looked at that and I said, wait, why? How can Nazis be allowed to be protest? Well, if you take away their First Amendment right, guess what you do to your First Amendment right? So that's why, you know, you gotta be careful when you do these things.
okay. Well,
One short comment.
all right, last thought, okay.
Just a very short comment to Steve, who started out. The difference is between, what's the difference between a person that we call crazy, the old way, and eccentric? That's the same as your question with rich and poor, and the answer is money.
Money. Sure. Money, the answer to everything.
So the law can be neutral and yet the effect,
Yeah,
the political effect.
the implementation, the application of the law can be very unfair.
Okay, well, thank you
Thank
very
you.
much, Paul.
Thank you very much.